Hello and welcome to the Family and Wealth Protection webinar. Before we begin, let me introduce myself. My name is Hani Amra and I'm one of the partners at Cornerstone Law Offices, and my firm focuses on estate planning and how to make sure that we keep your family out of court and conflict and make sure your kids would be absolutely protected if anything happens to you. And we do a lot of presentations because we love to educate parents on how estate planning does not have to be this scary thing. And it's actually a wonderful tool to help you protect your loved ones. But out of all the different presentations we do, this is absolutely our favorite. So it's so good to be here today to teach you one of the topics that is nearest and dearest to my heart, and that is kids protection planning. Our kids are our most valuable assets. I'm a dad, trust me, I understand this. Protecting them and making sure that should something happen, they are raised by the people you want in the manner you want, no matter what, is the true foundation of your estate plan. You see, the estate planning industry is flawed. It is generally focused on older people who may be nearing their end, when what it needs to think about are younger, growing families as well. What are their considerations? Have they made the right choices as far as their children are concerned? What about care and custody issues? That's why if you have minor kids, every plan must begin with a comprehensive kids protection plan, also called a family emergency response plan. More about me, I'm a husband and father of three beautiful kids. As you can see, I received my law degree from Western State College of Law. I'm also a member of the Wealth Council. We have offices in Anaheim, LA, Bellflower, Irvine, and Chicago. Okay, let's talk about the reason why you're all watching this webinar today. And that's because of your children. I'm going to ask you one of the most challenging questions we may consider all day. Now, don't get too scared by what we're about to cover, because I promise you I will not only help you to see where your kids and your assets may be at risk, but I'm also going to help you make sure that you make the right choices for the people you love the most so they stay out of court and conflict. So here's a tough question. On the most practical of levels, what would happen to your children if you and your spouse don't make it home today? Does anyone have an idea? See, most people don't realize this, but there are actually two time frames we have to think about when we consider what would happen to your children. The short term, the immediate time frame, and the long term time frame. Most traditional estate plans, if you work with a lawyer or if you handle it yourself online, will take care of the long term issue. And we'll talk about what I mean by that. But almost none take care of the short term issue. On a practical level, here's what would happen to your kids in the short term. If your children are with a babysitter or a friend at home or even at school and something happens to you, and you have not named the person who has legal authority to stay with your children, the police must call in Child Protective Services until they figure out what to do. Think about it. If no one has written legal authority to care for your children, the police would risk liability by leaving your children in your neighbor's care or babysitter care. They have no choice but to call in Child Protective Services. You have to name a short-term guardian and a properly formatted and executed document. Because even if you have named long-term guardians, and we'll get to this in a minute, they have to be adjudicated by a judge. Do you know how long it takes to get in front of a judge? Let me put it that way. It does not happen like that, right? So in these cases, you're still looking at possibly a matter of days, if not weeks, before that happens. As a dad, the thought of my children being taken into custody by the authorities, cared for by strangers, even temporarily, not understanding what's going on, scared me to no end. I just could not allow this to happen. And I know you don't want it to happen either. So we'll talk about specific steps you can take to avoid it in a few minutes. Before we talk about the specific steps you can take to ensure your children are never in that situation, even for a minute, let's talk about the long-term care for your children, should something happen to you. Again, you have to name long-term legal guardians in writing. I get told a lot. I've already had this conversation with my mother-in-law, and she has agreed to it, and so we're good. I say, well, is it documented? No, but we've had a conversation. And this is the law. If it's not written down and documented, it did not happen, meaning your kids would have to go to foster care. And in the worst case scenario, and we see this on a daily basis, if you have not named legal guardians in writing, families could fight about the court's decision. The judge could make the wrong decisions for you and your family, And the kids could end up in foster care meanwhile until this conflict is over and judge makes a decision. And then the judge must release kids from the foster care system. Let me tell you the story of another lawyer, a colleague of mine who went to law school with me, that will help to illustrate why it's so important to designate who you would want to care for your children. My lawyer friend has two children, and she knows exactly who she'd want to raise them if she could not. But let me tell you what would happen if she did not legally designate that person. Two people would want to raise her children if something happened to her sister and sister-in-law. Her sister is 26 years old and lives in West Hollywood. She's not married, she never had children, she does not have a stable job, she works part-time as a waitress. So on paper, she don't look financially stable. Her sister-in-law is 38 years old, owns her own home, has three children over the age of 9, has a steady job at a bank, and lives in the San Fernando Valley. Now, you get to be the judge. You've heard all of the facts about these two women. Who would you choose to raise her kids? Her sister-in-law, of course. I mean, the choice is obvious and wrong. The last person she'd want raising her kids would be her sister-in-law. Not because she does not love her, she does, but because in her heart she knows she would not parent her children the way she would want. On the other hand, she knows her sister would. Despite her circumstances, a court would never be able to judge that. And in the worst case scenario, her sister and sister-in-law could fight about the court's decision, and the kids could end up in the foster care. It's really easy to avoid the scenario, and we'll talk in a few minutes about how to. Before we talk about what you can do to have a kids protection plan in place to ensure your kids are never taken out of your home and into the care of strangers, let's talk about how they will receive your assets under your current plan or the state's plan for you. First, if you have no state plan, the state has an estate plan for you, and it's called probate. So what is probate? This is the way I've heard it described, and this is really accurate. A lawsuit you file against yourself with your own money for the benefit of everyone except who you want to benefit from your money. And it's a lawsuit that you're guaranteed to lose, okay? So who would want to go through this process? And a lot of people go through probate because they're not educated and they don't realize there's another way. Why is probate here? It is the judicial process of distributing your assets. So believe it or not, each and every one of us hearing this webinar, I know this for a fact, we already have an estate plan. So the state of California says you have to have an estate plan. Why? Because while we're alive, the only way we can transfer assets is by signing our name, right? But once we're gone, we can no longer sign our name. So if we have not set up something and signed it already that transfers our assets, it has to go to the courts, and only a judge could order those assets transferred. That's why probate is there. So first of all, probate is really slow. Here in California, it takes a minimum of 12 to 16 months, and during that time, your family might not have access to your assets. We'd like it to go faster, but we just cannot. It's also very costly. There are attorney's fees and executor fees, appraisal fees, court filing fees, bond premiums, and creditors' claims. A recent probate I handled had one piece of property valued at $1 million. The attorney's fees alone were almost $80,000, and $22,000 of those fees were statutory fees provided for by state law. The executor was entitled to another $22,000 in fees. These fees could have been avoided with a few $1,000s spent on a basic foundational estate plan. Probate is also public. I'm showing you Jackie Kennedy Onassis' will because I can. My point is that wills are totally public, and having a will does not avoid probate. In fact, it assures probate. There is even a saying in the legal industry that whenever there's a will, there's probate. And when a will enters probate, it puts all of the creditors out there on notice that your loved ones will be receiving money. And here's a problem with that. There are people out there who make a living off reading the probate records and seeing who's getting an inheritance. They know exactly how much they're getting. They know their address, they know where to find them, and they know everything because it's all a matter of public record. And they can go down to the court and scam them out of their money. There are a lot of scammers who go to probate court and make claims against deceased people who die without a plan. And they don't make outrageous claims. They want to try to get into that sweet spot where the executors say, if I challenge this, it's going to turn into a mini litigation within probate. That's going to cost me $20,000 to litigate. The scammer is asking for $15,000. So let me try to settle for 10. Finally, and worst of all, your children would be entitled to all of your assets outright without any restrictions at 18. My cousin received about 200,000 when he was 18. As a result, he did not graduate from college until he was over 30 years old, and he never really learned to support himself financially. He was not equipped to handle that lump sum at age 18. Most kids are not, and it does not have to be that way. So, the other way is to ensure that your kids receive their inheritance at different ages and stages and protected from lawsuits against them or even a future divorce. The good news is that probate is voluntary. Probate is totally avoidable. The only way to avoid it is to have a fully funded living trust. Just having a living trust is not enough. It must be fully funded. And this is a legal term of art, and it means that each and every asset you have must be owned in the name of your trust, including bank and business accounts, including change beneficiaries on your life insurance and on your retirement accounts. We get calls on a regular basis from people who have worked with lawyers or downloaded template estate planning documents who never transferred their assets into their trust. And then there's a death or an incapacity and they're calling us to fix it. But by then, it's too late. Just a few weeks ago, I had a client that called our office telling me that they were having to deal with the probate court, and they mentioned that they had a trust and they're confused and could not understand why they're still stuck in probate if they had spent $2,000 to work with a lawyer to create an estate plan. I looked through the binder he'd received from his attorney and saw a letter that said, "Congratulations on your estate plan. Now don't forget to move your assets into the trust." Well, client had never done that. Why? It was not because they were too busy. It was because their lawyer did not educate them and did not do it for them because this is the way their lawyer did things. So if you've ever done any of your own estate planning in the past, whether online yourself or with a lawyer, and you've got assets and they have not been transferred into your trust, or you've acquired new assets since then that are owned by you, not your trust, then understand that your estate plan would be failing you when the time comes. And again, this cannot be done once and never looked at again. Once you have your trust, all assets you acquire in the future must be titled in the name of your trust. So it's important to have a relationship with a lawyer who is going to review your plan with you each year to ensure your trust stay funded for maximum protection. Did you know that right now there is $58 billion across the United States in the various state departments of unclaimed property? And in our own state, there's $8 billion. Any idea how that money gets there? Well, it gets there because someone dies or becomes incapacitated and their family simply overlooks their assets because they were not inventoried. It's a time of grief and confusion, and those assets get lost. Think about your own situation now. If you were to become incapacitated or die right now, would your family be able to locate everything you have? Do you even know everything you have readily? Most people don't. Some accounts are only accessible electronically, and your family may not be able to get into your online accounts. Imagine what that would be like and whether your family would really know how to access everything you have. So we also do trust administrations when somebody dies. And one of the most challenging parts, and the part that takes the most amount of time, is when the trustee starts gathering the deceased assets, and that's when things could potentially go wrong. Because your trustee most of the time could be a brother or a sister, and think about it. It's so hard for your brother or sister to know what you own. So that's when we run the risk of some family members overlooking some assets. That's why we start off all of our planning process with a family and asset protection planning session to help you get more financially organized than you have ever been before, so that if you become incapacitated or die, none of your assets are lost. Before you meet with one of our lawyers, we will send you a package of information about the meeting with instructions on how to prepare for your meeting so you get the most from it. In that package, it would also include your homework, the Family Wealth Inventory. The Family Wealth Inventory is designed to track your assets over your lifetime so that when you pass, you are going to ensure your family does not lose any of your assets and become part of the $8 billion of California State Department of Unclaimed Property. So even if you never do any planning with us, The family and asset protection planning session alone is a hugely valuable process for you and your family because you will create a full inventory of your assets and ensure your family knows what you have. Once you become our client, we also ensure you will have an updated family wealth inventory every year at no additional cost. Listen, here's the coolest part of having a trust and working with one of our lawyers at Cornerstone, who are experts in estate planning and asset protection planning. We can build in asset protections in your living trust for the benefit of your family that not only ensure that none of your assets are lost to the State Department of Unclaimed Property, but you can also protect what you leave to your kids so that it can never be taken away by a spouse in a future divorce or even touched if your child is in a car accident or sued at some point in their future. You can give your children the gift of airtight asset protection for what you leave behind. Everything we mentioned so far covered how you can protect your family in the event of your death. But what about if you become incapacitated? 1 out of 4 people become incapacitated. You're in the hospital, not able to communicate. So this planning is really not about how much wealth you have. This is about your own care. If you're in the hospital, not able to communicate. Did you know that in the event of your incapacity, your will does not mean anything? It's not even valid. So meaning even your spouse cannot manage your affairs. I have a lot of clients saying, well, I'm married, I don't have to worry about that because my spouse can make medical decisions for me. And no, that's not the way it works. If you don't have that document, your spouse cannot make medical decisions for you. Your spouse is going to have to go to court to get a conservatorship order from the court to be able to make medical decisions. That means attorney's fees, court filing fees. It gets expensive. It's time consuming. And you can take care of all of that if you have a healthcare directive that says, if I'm ever incapacitated, here's who has authority to make medical decisions for me. And not all advanced healthcare directives are created alike. A standard form will likely not address any of the following. HIPAA waiver. Most healthcare directives have no provision for HIPAA, the Health Insurance Protection Authorization Act, which would prohibit your family from accessing your medical records if not properly handled. So even if you name an agent, because of the privacy laws, your doctor cannot talk to your agent about your medical condition. In fact, this happened to one of our clients. Her mom had a really old plan. It had not been updated since 1997, which is really common since most lawyers, as I told you earlier, put in place a plan once and lead their clients to believe that it's done. So mom had never updated her plan. Her attorney had never contacted her after HIPAA went into effect, so she did not know there was a big hole in her plan. She ended up on life support at Kaiser, and daughter wanted to have her transferred to a respiratory center where she could be weaned off the ventilators because mom did not have this one form. It took 3 weeks for daughter to have her transferred. Those 3 weeks very likely cost mom her life and cost daughter a huge amount of stress. So we also review plans for people that have had them done by other lawyers. And again, I see lots of plans, even that they were done 5-10 years ago, that don't include HIPAA waivers. That's a problem. We want to make sure that that's part of your healthcare directive. Another important provision is your desire for hydration and nutrition. And I want to share with you the story of Terry Schiavo. This is a famous case. And Terry Schiavo actually had a healthcare directive, but it was just a generic one and it did not address whether she should continue to receive nutrition, hydration in the event of incapacity. And there was a big disagreement between her parents and her husband, with one wanting to provide it and the other wanting to remove it. Cost her family hundreds of thousands of attorney's fees. 11 attorneys were involved in this litigation that lasted over 7 years in court. Another important provision that must be included are your Islamic burial circumstances, no autopsy provisions, and provisions for specific Islamic desires regarding your care, including diet, visitors, and other activities. So even if you don't have assets that will get stuck in court or would be lost, you very likely do have Islamic wishes about how you want to be buried, how your care would be handled, and by who if you could not communicate. Because even though the state knows that you are Muslim, they don't have to honor any of your Islamic desires because it's not in writing and that's really not the default plan under state law. So why you need an advanced healthcare directives? to turn your Islamic wishes into directives and ensure your plan covers specific Islamic guidelines. Not just using a standard state form that names a person, but being specific regarding how you want to be cared for and who do you want to be making care decisions for you Islamically. So what can you do today to do the right thing for your family? So if you want to go through a free educational process where you get informed, empowered, educated about your specific situation, if you want to make sure that none of your assets get lost when you die, then it's all about coming to meet with me for a family and asset protection planning session. This is a process that our clients absolutely love, and you will too, because it supports you to get more financially organized than you ever have been before, keeps your assets out of the State Department of Unclaimed Property, and give you the peace of mind of knowing your family is taken care of and you have made the right choices for the people you love the most so they stay out of court and conflict. And during the process, you are going to actually choose your own fee for the planning you do. By the end of it, you know with certainty you are making the best legal and financial decisions throughout your life. And your family will know how much you cared about and loved them in the event of your incapacity or death, because everything will be so well handled. Ultimately, this is something you do for the people you love the most. So call us today at 714 678 9770. That's 714 678 9770 to schedule your family and asset protection planning session. Thank you.